It is so good to be back here at the Whitman College reunion. As an important civil rights lawyer in Seattle, I think it is important to stay connected to my roots.
I am also an important civil rights lawyer in Seattle. Although I guess that is a bit redundant. The New York Times ethicist would surely agree that there's no such thing as a trivial civil right.
You and I are kindred spirits. I also love the New York Times ethicist. I loved his latest musings on how to avoid forcing children into stereotypical gender roles. Speaking of civil rights, I'm sure you've reviewed the Ninth Circuit's latest holding in Bryan v. McPherson.
Oh yes. Judge Wardlaw's analysis was impressive. Is she diverse? I certainly hope so. Oh well, I guess that is beside the point. Her conclusion that taser applications are intermediate-level force really provides an avenue for holding police accountable. I could not agree more with her analysis of how barbaric it is that those darts actually penetrate the skin.
I likewise approve of her well-reasoned opinion. For years I have focused on the electricity aspect of the taser. As I'm sure you are aware, the ACLU and Amnesty International conclude that hundreds of people have actually been tased to death. I looked right past the barbarity of the barbs penetrating the skin, no pun intended.
Yes. Those darts or barbs are nasty. In fact, I've really been conflicted over fly fishing for the same reason.
Do you fly fish?
No, but I really enjoyed that movie produced by Robert Redford about fly fishing in Montana. But considering the barbs and all, I may not go to the Sundance Film Festival this year. Has Amnesty International and the ACLU linked any deaths to the darts simply penetrating the skin? If they haven't, I am sure it is just a matter of time.
I'm not an important civil rights lawyer because of the money. But I must say, I think Bryan v. McPherson will definitely improve my bottom line. Our son has applied to some very exclusive preschools near our home in Madrona, and those places aren't cheap.
I am sure your son will get in. My daughter was just accepted at the Bush School. She worked very hard in preschool and I think that swung things in our favor. Like you, I did not become an important civil rights lawyer to make money. But a few fat settlements would make those trips to the Galapagos Islands to retrace Charles Darwin's journey a little easier to handle. Tasers is intermediate force. I smell settlements. Better yet, I smell victory at summary judgment. We'll finally be able to get past those damn jury trials. I am sick of the lawyers over at Keating Buckland. A jury trial just gives them an opportunity to pander to the rabble.
Agreed. I hate juries. I have great people skills, and I love helping people, especially those from diverse people groups, but juries are a different situation. I'm sorry, but just because my client has some credibility problems or substance abuse issues doesn't mean the Constitution goes out the window.
Hopefully, with the Ninth Circuit now ruling that tasers are intermediate force, what actually happened or why the police tased someone will become irrelevant.
Why someone got tased is irrelevant. It is obvious why tasing occurred is for the same reasons that other uses of force are applied. It's either racism or naked aggression.
I typically try to find clients that have been harmed by the police for both reasons. The Seattle Times is generally not as interested in the naked aggression angle. But hey, if finding noble woodcarvers was easy, there'd be a lot more important civil rights lawyers, right? Well, I better get back to my wife. We forgot to refill her Prozac before coming over. She will sometimes self-medicate if left her to her own devices. She is also an important civil rights lawyer.
I leave you with this. As Brother Malcolm X said, and as I apply to collecting my 38% contingency agreement, by any means necessary.
Great talking with you. Bryan versus McPherson. The Ninth Circuit speaking truth to power.